Mr. Wu, Rule 5, Section 27 states that the debate is for this purpose may speak, shall have the right to open and close the debate. And that the move or any proposition, and that it must be on the issue in front of the body, Mr. Wu. So it's Rule 5, Section 27. Mr. Wu.
Mr. Speaker.
Mr. Wu.
Parliamentary inquiry.
Please state your inquiry.
Is the issue before the House the bill itself, or has it been withdrawn?
Mr. Wu, Representative Davis has been recognized on her amendment. So what's before the body is her amendment, Mr. Wu.
Mr. Speaker.
Mr. Wu.
Parliamentary inquiry.
Please state your inquiry.
Is it to your understanding, the
chair's understanding, is that your point?
Is that Representative Davis's amendment strikes out a provision of the bill?
It does, Mr. Wu.
Okay. And what provisions of the bill specifically does it strike out?
Mr. Wu, you can direct your substantive questions to the author of the bill.
Well, Mr. Speaker,
Mr. Wu.
I'm trying to figure out what I can and cannot ask, and whether or not it's germane. And I've been told just now that asking about legal privileges...
Mr. Wu, you were asked to keep your questions to the amendment. Nothing was specifically stated to you as to what you could or could not ask, other than pointing out that we request the members when they are questioning authors of amendments that they keep their questions on the subject of the amendment before the body.
Thank you for clarifying, Mr. Speaker.
Thank you, Mr. Wu.
Mr. Speaker.
Mr. Martinez-Fisher.
Parliamentary inquiry.
Please state your inquiry.
Mr. Speaker, I'm trying to understand the interpretation you gave the body under Rule 5, Section 27.
Yes, sir.
Could you repeat that for me, please?
Certainly. What our statement is that under the rules, the debate is limited to the proposition before the House.
And that is
at this time, the proposition before the House is the amendment laid out and being debated.
And that is the Chair's reading of Rule 5, Section 27?
Yes, sir.
Mr. Speaker.
Mr. Martinez-Fisher.
Rule 5, Section 27 pertains to the mover of a proposition. So who is the mover of a proposition in this exchange between Representative Wu and Representative Davis?
Representative Davis would be the mover of the proposition. So,
Mr. Speaker, if Rule 5, Section 27 applies and only applies to the mover of the proposition, why is Representative Wu limited in his ability to debate under Rule 5, Section 27, which pertains specifically to the right of opening and closing a debate, but nothing about the debate itself?
Mr. Martinez-Fisher would also direct you to Rule 5, Section 22, that also requests that the address of the House from the microphone and from the reading clerk's desk and shall confine all remarks to the questions under debate, avoiding personalities.
You shall confine all remarks to the question under debate,
correct,
avoiding personalities.
Correct. That's the final sentence. It's not the entirety of that rule.
So that we're clear, we're not talking about Rule 5, Section 27 as it was initially brought to the body's attention. We're really confining this debate based on the rules under Rule 5, Section 22?
Actually, Mr. Martinez-Fisher, we're talking about both because Rule 5, Section 22 and Section 27 address what the individual laying the proposition out and what the individuals from the back may keep their comments to.
Well, respectfully, Mr. Speaker, parliamentary inquiry.
Please state your inquiry.
Section 27 under Rule 5 has nothing to do with the back mic.
I understand, and that's why we also were pointing me to Section 22 and Section 27, both sections.
And when under Rule 5, Section 22, as it pertains to the back mic, this is a rule that addresses how members are to speak in debate, and when a member desires to speak or deliver any matter to the House, the member shall rise and respectfully address the speaker as Mr. Speaker or Madam Speaker, and upon being recognized, may address the House from the microphone at the reading clerk's desk, and shall confine all remarks to the question under debate. Mr. Speaker, Parliamentary inquiry.
Please state your inquiry.
Is there a reading clerk's desk at the back mic? Mr. Speaker.
Mr. Martinez-Fisher.
Mr. Speaker, I know that there's not a reading clerk's desk at the back mic. I know the chair is advised that there's not a reading clerk at the back mic. I think this is a debate. It's a very divisive debate. It's very ideological. And if there's a moment where there is a debate that the members have the opportunity to have a debate, I think it would be fair for the body to have that debate. There have been a number of instances where this debate has been arbitrarily cut off for good reasons or for bad reasons. But on the floor of this House, the members ought to have the ability to debate. And all I'm asking is for the chair to give some consideration to the members on the back mic to be able to ask the questions for the purposes of engaging the debate of the mover of any proposition, whether it be Representative Davis or Representative Lautenberg.
And certainly, Mr. Martinez-Fisher, we agree with you as long as those remarks are confined to the amendment or proposition before the body.
And I think that, obviously, Mr. Speaker, respectfully, we don't agree in that sense because that's not a requirement under the House rules. That may be a request of the chair, but that is certainly not in our rules. And our rules govern our ability to represent our constituents on this floor. These are rules that we draft, we debate, and we adopt every session. And I don't see a rule that says that.
Well, respectfully, Representative Martinez-Fisher, we see Rule 5, Section 22 that specifically says, shall confine all remarks to the question under debate. And it also in Rule 5, Section 27 says that the debate shall be, one moment, let me find the area, the proposition, must speak on the proposition. And so when you combine those rules, which they're under the same rule, Section 22, Section 27, it's been historically understood because it's always been in the rules that you speak to the proposition, otherwise known maybe as the amendment, before the body, Mr. Martinez.
And Mr. Speaker, respectfully, if we blend all the rules, we have Rule 5, Section 25 that says you shall not interrupt a member when he has the floor. Representative Wu has the floor when he was interrupted by the chair. And so if these rules all run together, then why aren't we objecting under Rule 5, Section 25 that Representative Wu was interrupted by the chair when he had the floor?
The chair has the right to enforce the rules of the House, Representative Martinez.
Wonderful. And under Rule 5, Section 25...
the chair has a duty to do that.
And respectfully, then I would urge you, in asserting your duty under Rule 5, Section 25, to not interrupt a member who has been recognized and has the floor from the back mic for the purposes of speaking in debate, which is not only in our House rules, it's also in our Texas Constitution.
Representative Martinez-Fisher, but our rules limit the debate to the proposition in question, and it is the chair's duty to enforce and govern those rules.
And respectfully, Mr. Speaker, we can have two conversations because the substance of the amendment that's before us is striking the entire bill, which tells me under the amendment we can talk about anything that is being proposed to be struck under your narrow interpretation. So under that aspect, if the chair is aware that the amendment pertains to the entire bill, how could Representative Wu or anyone else's remarks be improper for being outside the scope of the amendment?
Thank you, Representative Martinez-Fisher. I think we all agree that we can have a good debate without putting personalities or personal issues into it, and we look forward to continuing.
Mr. Speaker, I appreciate your time. Thank you.
Thank you.
Mr. Speaker.
Chair recognizes Representative Davis to finish her time.
Mr.
Representative Menendez.
Thank you. It's okay. Mr. Speaker, how much time does Representative Davis have left?
1 minute.
Would the gentleman yield for questions?
Yes, absolutely.
Lady yields.
Representative Davis, I sat through many hours on the committee listening to the debate, the people testifying for and against, and when the representative for the Texas Hospital Association came before us, she specifically came before us to testify against the section that requires the privileges. And she said that the hospitals did not feel that they would be inclined to provide, they couldn't be forced to provide admitting privileges. And so, in doing so, if we continue with the bill in its form without your amendment, don't you agree that this bill has the potential to be unconstitutional?
Yes, absolutely. I think that whether we ban abortions by passing a law banning abortions or by passing so many regulations and restrictions that the result is a de facto ban on abortions, the result is the same. And I think that it will be held unconstitutional. And I think that...
Representative Leach raised a point of order. At this time, just by a point of order. Order is well taken. It's the same. Chair recognizes Representative Laubenberg in opposition to the amendment.
I respectfully move to table this amendment for the same reasons as the previous amendment, that there is no limit on the term of the pregnancy. There's no requirement to report to law enforcement. And again, it inflicts pain on the child being aborted at 5 months and beyond. That this is not guaranteed to heal the pain and suffering that a woman has undergone through a horrible situation. And I ask the members to stay with me. Thank you.
Chair recognizes Representative Davis to close.
Thank you, Mr. Speaker and members. This has been a very constructive discussion that we've had today. As I said when I laid out this amendment, I don't think there is anyone on this floor, whether you are a Republican or a Democrat, that wants women to have abortion. I think when a woman is faced with that decision, it's got to be one of the most difficult decisions that she would ever make. So you have an opportunity to pass legislation that will protect the unborn, which so many of you claim that you want to do. This amendment will ban abortions at 20 weeks. We've heard Representative Laubenberg talk about 20 weeks, 5 months. I find it would be unusual that anyone would say it's completely tolerable to allow a woman to carry a child into the 5th month and then use abortion as a means of birth control, because that is unimaginable to me. But there has to be exceptions, and that is what my amendment provides. And it strikes the rest of the language of the bill that I believe to be unconstitutional and will result in a ban of all abortions. Again, this is not a Republican versus a Democrat issue. I think we all want what's best. And I know that we've been told, just keep the bill clean, let's just fight off all amendments. But we are here, and the nation is watching what we are doing today on the floor. Not just the people in the gallery, but the entire country. So now is not the time to play political football with women. Now is the time to pass good policy, good pro-life policy. So I will ask that you vote against the motion to table.
Mr. Speaker,
Mr. Anchia, for what purpose?
will the gentlelady yield?
I will.
Yield. Lady yield.
Thank you, Representative. I just wanted to walk through the public policy balance that you're trying to strike here. You are not removing the 20-week ban in your amendment. Is that correct?
That's correct.
You have included some reasonable exceptions to the 20-week rule that do not swallow the ban, but instead reflect the sense of a body that is trying to be sensitive to balancing the interests of a woman and balancing the interests of a fetus, correct?
That's correct. I think on this issue, there is just no common ground, and I would never ask someone to change their faith or their fundamental philosophy, but as a policy-making body, oftentimes we do have to find, or at least try to find, some common ground. And I think that this amendment and the bill that would result is common ground, because I don't think that anybody wants to see women using abortion as a means of birth control, and let alone in such late stages of pregnancy, but that there has to be medical exceptions. The committee heard hours of testimony about how women's lives can be affected through pregnancy, and there may be medical reasons why she has to terminate. That 20-week is a benchmark in a lot of ways for some testing that goes on, that you can detect severe fetal abnormalities that you may not be able to detect until that 20-week mark. And so that's such a good exception. It's already in the bill right now. So really all I'm adding is the rape and incest exception that Chairman Thompson spoke so eloquently about. And again, I want the body to read this. It requires a possibility of serious self-harm or suicide. So if someone is presenting at 21 weeks wanting an abortion because they are a victim of rape or incest, they also have to present a possibility of serious self-harm or suicide in order to have that procedure done. I have done everything I can to make this bill as pro-life as I know this state is, but also embracing good policy and respect for women and the Constitution of the United States.
And Representative Davis, just to underscore, you've had experience while you're not a physician or a healthcare worker. You've had experience in this area, have you not? Through some of your public service, maybe through your volunteer service.
Well, I serve on
in the district that you represent.
Yes, I serve on the Public Health Committee. I represent the Texas Medical Center. I represent more physicians than any other state rep in the state of Texas, which is something TMA will always remind me of.
So from a moral perspective, in addition from a practical perspective, things that you see in medical science, the feedback that you're receiving from the physicians that you represent in your district, this seems like a reasonable approach, balancing the interests, and for those members who consider that 20 weeks a bright line, keeping that in the amendment, but removing the other things in the bill.
The undue burdens that the rest of the bill puts in place in violation of federal case law under Planned Parenthood v. Casey.
In order to make it constitutional, is that correct?
Correct.
And Representative Davis, you are a lawyer and you are familiar with the case law, and you believe that these changes would actually make it constitutional. Is that right?
I think that it would definitely have a better chance at surviving a constitutional attack. Clearly, I think the courts are giving more. When I do an analysis of the case law, I think the courts are definitely leaning in the direction in favor of the states and the compelling state interest, and especially as science and medicine evolve. At one point, the discussion was all about viability, but we can see that babies are viable earlier than they once were. So viability is not necessarily the test, but I think the test is undue burden. And I think the U.S. Supreme Court has made it clear that states are prohibited from putting undue burdens to access. Now, that doesn't mean that the state has to build facilities where women can get abortions. Absolutely not. But we cannot create legislatively these barriers and essentially a de facto ban by requiring physicians to have hospital privileges, which the testimony in the record is that they will not be given those privileges, will result in the de facto ban and thus the unconstitutionality of this legislation.
And one of the further things I find attractive about your amendment is that it restores the decision-making authority to the physician, right? So one of the things that your amendment does do is it allows the physician to call balls and strikes, not a member of the legislature, not a lawyer, but a physician who's been responsible for the care of that woman. It allows that person to call balls and strikes on whether there is a serious health issue that might arise. And that's important, and I know you're aware of this statistic, but only 1.3% of all abortions that take place in the state of Texas take place after this 20 weeks. So we're talking about a narrow band of abortion. And then secondly, 95% of those deal with the health of the woman and some serious health consequences. Is that not right?
I think that's absolutely correct. And I think it's also, and I may have mentioned this, that it's already state law that any abortion that is performed at 14 weeks or later must be performed at an ambulatory surgical center. So there are laws on the books now meant to protect women and the environments in which they receive care. But this is just going so far to the point where there will be no care.
Just to underscore, for the body, for the people in the gallery, for the people who are watching at home, you are actually for a ban at 20 weeks with reasonable exceptions, and people who vote for your amendment are still going to be voting for a ban on 20 weeks with reasonable exceptions.
That's correct. I think I will be voting. I'm offering this amendment. I will be voting for this amendment, and I hope that everyone here can support this amendment. And if you are truly serious about making good policy decisions, this is the amendment to support. If you care more about politics and your next primary elections, quite frankly, then you're probably just going to agree to move to table this. But this, I think, is the best policy on this issue, which is such a controversial and personal issue. And it is hard for me to even discuss this.
Clerk has raised the point of order. Ladies' time expired. Point of order is well taken and sustained. Representative Davis sends up an amendment. Representative Lavenberg moves to table. This is on the motion to table. It's a record vote. Clerk, ring the bell. Show Ms. Davis voting no, Ms. Lavenberg voting aye. Show Representative Vanchia voting no. Have all voted. Being 89 ayes and 56 nays, the motion to table prevails. Chair recognizes Representative Hunter for a motion.
Mr. Speaker, members, I request permission for the Committee on Calendars to meet while the House is in session at 12:45 p.m. today, July 9, 2013, place 3W9, to consider a calendar.
Members heard the motion. Is there objection? Chair is none so ordered. Following announcement, the clerk read the announcement.
Committee on Calendars will meet at 12:45 p.m. July 9, 2013 in 3W9 for a formal meeting to consider a calendar.
Talking to you.
Excuse Representative Hunter, Cook, Kemple, Frulo, Guerin, Representative Doug Miller for calendars meeting. Motion Representative Raymond is objection. Chair is none so ordered. Chair recognizes Representative Raymond for introduction.
Thank you, Mr. Speaker. Members, I'd like to take a second to recognize my city councilman who is up here somewhere in the gallery, Charlie San Miguel. Members, let's welcome my wonderful city councilman, Charlie San Miguel. Tell him that his goatee looks good. We like that goatee. Good to have you here, Councilman. Thank you.
Mr. Speaker,
It's getting to our purpose.
parliamentary inquiry.
State your inquiry.
The House rules provide for a dividing of the question in Section 5, in Rule 5, Section 43. Is that correct?
Yes, that's correct.
Parliamentary inquiry, Mr. Speaker.
State your inquiry.
How would I get that motion before the House, sir?
Giddings, you would request to be recognized for that motion.
So I just need to approach the Speaker. Is that parliamentary inquiry? I should just approach the Speaker.
That would be great.
Thank you.
Come on down.